Magandang araw po sa inyong lahat. Good afternoon. Maraming salamat po sa inyong pagpapaunlak sa aming paanyaya na tayo ay muling magharap-harap, makita sa ganitong pagkakataon. Nais po naming basahin sa inyo ang isang statement po na inihanda namin at pagkatapos ay bibigyan kayo ng sipi ng kopya nito. June 18, 2016. This week, we received the decision in favor of the church, finding for the plaintiff and ordering the defendants to immediately vacate the premises. On January 14, 2016, after months of toleration, the Iglesia ni Cristo decided to file an eviction case against the occupants of 36 Tandang Sora. We faithfully waited for 5 months for this decision. We did abide by the procedures laid down by the law. In a 6-page decision dated May 26, 2016, served upon the plaintiff through its counsel last June 16, 2016, Presiding Judge Ann Perpetual S. Rivera Sia of the Manila Court ordered the aforenamed defendants, expelled members of the Iglesia ni Cristo, to immediately vacate the INC property at 36 Tandang Sora Avenue, Quezon City. Under the rules, a judgment on an unlawful detainer case is immediately executory. Proper steps will be taken. We gladly welcome this recent decision as another vindication of the Church. That is all. Baka po meron kayong mga katanungan, nais linawin. Isa-isay po natin. Statement lang sir. Sandali lang po. Statement lang po ito. Hindi ito yung actual na decision. Ano po? 6 pages po yun.
Sir, yung pong QCRTC decision, kailan mo i-implement ng court ho ba yung o sheriff ng QCRTC? Kailan po yung exact date, yung hour ng pag-implement po yung court order na eviction po?
We'll allow Attorney Moises Tolentino to answer the question.
Procedurally, after the decision of the court has been promulgated, we can file a motion for execution. In fact, we have done that because from the tenor of the decision of the METC Branch 12 in Manila, the decision is immediately executory. The tenor is very clear. The court has ordered the defendants, the occupants of number 36 Tandansora Avenue, Quezon City, are ordered to immediately vacate. Those are the words of the court. Now, we have filed a motion for execution, which we intend to have the court in Quezon City heard on Friday, or in Manila on Friday, June 24. Thereafter, we expect the court to issue a resolution, and we will be using the writ of execution to be issued by the court and ask the service officer, the sheriff of the court, to implement the decision of the court.
Sir, has the camp of the Manala siblings been informed of this decision?
The decision of the court in a case like this is usually served on the lawyers, the counsels. So we receive on the part of the Iglesia ni Cristo the decision through our lawyers on record. The defendants who are occupying number 36 Tandansora likewise should have received their copy of the decision through their lawyer.
Sir, more or less, kailan po yung eksaktong araw na kailangan physically mag-evacuate na sila from the premise?
Now, as I told you, we will wait for the issuance of a writ of execution. And that is what we are asking from the court through the motion that will be heard on June 24. We expect it to be issued not very long from the date the motion is submitted for resolution. So we cannot give you the exact date, but it will not take long.
If I may add something to that, July of 2015, when they were expelled from the church, we already expected that they would vacate the premises voluntarily because they are aware of the rules governing allowing a member of the church to occupy church housing. But since they chose to ignore those rules, the Iglesia ni Cristo, through its counsel, decided to file this case. So hopefully, now that they are aware that even the court agrees with our position, they will, of their own volition, vacate the premises. Hopefully. Any other questions?
Sir, pwede po ba mag-ano yan, sir? Mapasensya na kayo. Motion for reconsideration po sa RTC level din, pwede pang pumanik sa Supreme Court. Yung procedural lang po kung ganun ho ba mangyari.
The case is a what we call an unlawful detainer case. There are specific rules under the revised rules of court which mention those pleadings that are prohibited, because this is a case that is tried under what we call the summary procedure rules. And a motion for reconsideration is among those pleadings that are specifically not allowed. So that is precisely why in the decision of the court, the presiding judge who penned the decision made it clear that the order to vacate the premises is immediately executory. The defendants are ordered to surrender peacefully the possession of the premises to the plaintiff, which is the winning party. That is the Iglesia ni Cristo, who is the owner of the property in question.
So, sir, just to clarify, they can't file an MR?
No MR is allowed under the rules on summary procedure. The lawyers of the defendant know that very well. In fact, all practicing lawyers are aware of those rules. As mentioned by Brother Edwil Sabala, we are hopeful that the defendants will be gentlemen enough to abide by the decision of the court. We expect them to honor the procedures and the law relative to this issue, because we are aware that they are being advised by their counsel on their rights and obligations in a case like this. So we are awaiting. If there is a voluntary move on the part of the defendants, we will be thankful for that. Otherwise, we will have to resort to the procedure laid down under the law, under the rules of court. And that is precisely, we are filing a motion for execution.